Samadhi, it's 3 minutes past the hour. I think we can get started. I'll give a brief introduction and then hand it over to you.
Okay.
All right.
Sounds like
thank you everyone for joining. This is our first Legal 101 startup, Legal 101 for startups for 2021. What a year has been so far. I hope that many founders are thinking about incorporating their startups, or those who have their startups and thinking about their structures. Today's workshop will be beneficial to you. So before we start our workshop today, I wanted to welcome everyone to our webinar. This webinar is presented by Open Silicon Valley. To stay informed about this webinar and some of the other webinars we will be doing in the future, please visit us on our Facebook page. We have presence on LinkedIn, Twitter, or you can just visit our website as well. If you have any questions or would consider joining Open Silicon Valley, you can always email us at info@opensv.org. We do also have some members-only events where you'll get a chance to meet with most of our charter members and be part of some of the workshops that are only exclusively for members. So we hope you would consider joining us. Having said that, a few housekeeping items. Please keep your lines on mute. There is a Q&A window. So whatever questions you have, if you can please type in your Q&A window, we will respond to your questions as we go along in the workshop. We have some dedicated time for Q&A as well. The other way to ask questions is just raise your virtual hand. Either myself or Madiha will unmute your line, and then you'll get a chance to answer questions live. First 30 minutes, Madiha is going to go over her presentation, which will talk about structures, about startups, and what all you need to know, and things, do's and don'ts. And then we'll dive right into a little bit more in-depth discussion based on your individual questions. About Madiha, Madiha is a senior associate. She's a lawyer for Pillsbury, Winthrop, Shaw, and Pittman LLP in Palo Alto. Madiha focuses on securities transaction and general corporate matters, including IPOs, mergers and acquisitions, venture capital financing, and some other transactions as well. Madiha advises entrepreneurs and startup companies across a variety of industries through all stages of their life cycles, including formation, seed, venture capital financing, and mergers and acquisitions. She also advises public and private companies of all sizes in public offerings, mergers and acquisitions. Madiha is also a member of Open Silicon Valley. We are very fortunate to have her with us today. And Madiha, thank you so much for giving us some time. I know you have a really busy schedule. It's start of the year, a lot of things happening. So we are truly grateful for your time and commitment today. So with that, I'll hand it over to you, Madiha.
Thank you. And good morning and assalamu alaikum, everyone. Thank you for joining. I just want to see if my presentation is being shared now. Farhan, do let me know when you guys can see the presentation.
Yes, we can see it now.
Okay, so as Farhan told you, I am an attorney, a corporate law. I practice corporate law with Pillsbury, Winthrop, Shaw, Pittman in Palo Alto. I represent corporations, like companies, and we will do work from anything from your inception right up to your exit event. What that means is that we'll, if someone comes to us, a corporate, to form a corporate entity, we'll form you and will sort of advise you and do your legal work right up to your exit event, whatever that exit event might be. Some companies get bought out by other companies, like resulting in a merger or an acquisition. Some companies become so large that they ultimately want to become a public company. So they go and get themselves listed onto NASDAQ or NYSE. So there's like, you know, a range of exits that companies face, and we're the ones who will actually do all the legal work to ensure that you have a good exit, whatever that might be. So without further ado, this session is just geared to give you a broad overview of the entire incorporation process. So you're an entrepreneur, right? And what you have is, you have an idea. What do you want to do? Like, you're sitting one day and you come up with an idea that, you know what, I am going to be the person who puts into motion 6G. I'm sick and tired of 5G. That's too old school now. And I have this brilliant idea of how I can get 5D or some other new technology into the hands of users. And this is a multi-billion-dollar idea. You're super excited about it and you start working on it. But what does that mean? Like, are you a startup at that point? It all starts with the idea, but how do you take your idea and put that into realization? So if you're a single person and you're working in your little garage or your room, and you're just working on something, you're coming up with your product, you're trying to translate your idea and bring it to fruition in the form of some alpha product, which you're going to go into your beta phase later. At what point do you need to actually set up your entity? And why should you incorporate in the first point? Everyone's asking like, oh, I have this idea, I'm just doing my own work. Why do I need to go and incorporate? Now, the first important thing to realize is a corporation or an LLC. Any corporate entity is a person in and of itself. Under the law, your entity has its own personality. It has legal rights to enter into contracts. It has certain liability obligations and everything. So you want to incorporate because you don't want to take on the liability of something that is not personally you. For example, for people who are working in med devices or like, medical related fields, you have some idea, you have a product or something like that, you want to test it out. Now, do you want to incur the liability personally of your product? You don't. So you need to have a corporate structure, an entity where, you can house all your liabilities. If you want to take a loan to help give you certain financing, to, help build out stuff, do you want to take it personally? Or would you rather have an entity which, you can go to the bank, set up your bank account for your company, and then, you can ask for loans and all. So there's a lot of benefit to incorporating. Now, the other key issue is, when do you need to incorporate? And I always tell people that if you're two founders, if there are two people who have come up with the idea, you should incorporate, because it's human nature that you might have differences of opinion, differences on how you see your company progressing, what route it should take, how you need to develop product and everything. And so if you have your corporate structure set up and you have rights and obligations of the founders and what their participation is, who owns what, the company owns the IP, if all those things are actually thought out and resolved in time before, things start to go down wire or your differences of opinion start to surface, it's always best practice that way. So I say, if you're two people, please incorporate, make sure that you're on the same page on terms of who gets to be on the board, who's going to be the CEO, who's going to be the CTO. All these things, if they're resolved earlier in time, it saves you a lot of heartache later. So what is actually the process? People think, oh my God, it's like such a big thing. I got a company incorporated and all. The actual process of setting up a company is very simple. It can be done in as little as, sometimes under 2 hours in Delaware, because Delaware actually allows you the ability to file, and they'll return you your charter or your evidence of filing within the hour. So for Delaware corporations, especially, the process is very quick. You just need an action of an incorporator. You need a charter, a certificate of incorporation, which you file in Delaware. And lo and behold, when evidence is returned within the hour or 2 hours, your entity has been set up. But just because your entity has been set up does not mean that, all your problems are resolved, that you're good to go. There's a plethora of paperwork and documentation which needs to be resolved at this point. So we come to all the other documents that need to be prepared, that need to be agreed upon between all these founders and these various groups before you can actually start to function properly as a company. Now, your first document is the action by the incorporator, which I told you that once, let's say I'm the one you come to and you say, oh, I want to set up a C corporation in Delaware. So I will file that charter for you on your behalf in Delaware. So I'm the incorporator. But as soon as your evidence is returned from Delaware and you're set up, your legal entity has been set up, I am going to resign as the incorporator. I'm going to make sure that you adopt bylaws and a board member, 1 or 2 board members are appointed, and I'm out of the picture because I don't want to incur liability further than what I've done. Then you have bylaws. Now, bylaws is sort of like the legal or like, your rules and procedures on how you do things within your corporate entity are all put in the bylaws. For example, what is your board size? How do you increase your board size? How do you decrease it? When do you call a board meeting? How do you call a board meeting? How many directors do you need present in your board meeting for quorum to be reached and process, like, for the board to duly approve things? All of that is going to be in your bylaws. When do you call a stockholders meeting? How does the stockholders meeting be done? Who's going to conduct the stockholders meeting? All of these things are going to be in your bylaws. Then you'll have a organizational board consent. Now, you're doing so much work at this very early inceptional stage of your corporation or your limited liability company or whatever corporate structure that you have. So your board will have to approve your stock issuances. Your board will have to approve a option plan if that's what you're putting into your organization. Your board will have to approve you going out, getting an EIN number, qualifying in other states. There's a plethora of things that your board has to approve and put it in proper record that, the board considered all these things and the board acted on these things. So you'll have a board consent. Then there's certain things that a company cannot do without the stockholders actually approving those actions. For example, your stockholders need to approve any indemnification obligations that your company is taking with respect to the directors. Your stockholders have to approve the adoption of your employee stock option plan. So all of that is going to be in your stockholder consent, which your stockholders will approve. But then, who are your stockholders? How do you get stockholders? Stockholders you'll get when the entity is going to issue stock. And a stock issuance is a very important thing in and of itself because you need to ensure that there's proper documentation in place. You're in compliance with all federal and state laws for securities issuances. So the stock issuance in and of itself is a very, very important, critical part of your organization at this point. And you want to ensure that everything's been done by the letter of the law and done well. Then you're going to adopt a stock option plan. There's paperwork and a whole plan that has to be documented, that has to be put in place. And founders, especially if you're a first-time founder, you don't know how to go forward with this stock option plan. How do you issue stock under it? What are the steps that need to be taken? So, the benefit of doing this with a law firm is that you'll have a little bit more hand-holding And people will sort of walk you through the process that what do you do with your option plan? What are the other papers associated with an option plan? What are the different issuances that can be made under your option plan? Do you give acceleration? Do you not give acceleration? How does your stock vest? How does it not vest? Who vests in which, under which formula? All of that thing, you know, a lawyer will sort of guide you through that, especially if you're a first-time founder. And then qualifying to do business in other states. Now, what happens a lot is that typically you'll have a Delaware C corporation, and then you're going to qualify to do business in California or whichever state that you're also headquartered in. So these are things that need to be done and that need attention at a very early stage. And you want to make, you know, you want to ensure that all of these things are done properly. Now, the other thing that you need to think about and think through is what form of a legal entity am I going to produce? Do I want a corporation? Do I want a limited liability company? And a lot of people, founders especially, excuse me, they come to us and they'll say that, oh, you know what, I want a limited liability company because I've heard that there's no taxation issue. Now, taxation at a very high level, what happens in a corporation is the corporation can be taxed as either a C corporation or an S corporation, right? Those are the two available taxation options that you have. In a C corporation, what happens is that the corporation will pay corporate income tax on profits, and then the shareholders will pay personal income taxes on profits that are paid to the shareholders as dividends and all. So what that creates is a double taxation structure. We call it double taxation, that, you know, the corporation is paying taxes and lo and behold, the shareholders are paying taxes too. So you're sort of getting dinged twice. But this is normal procedure. And anyways, you know, most corporations, they have, you know, you have NOLs and other stuff. So your corporate taxation problem is not as exacerbated as things are made out to be. So 9 out of 10 times you always end up with a Delaware C corporation. But just in general terms, that's what on a very high scale, that's what the issue is. And then you have an S corporations where your profits, they pass through the shareholders like in an LLC. But for an S corporation, there are stringent requirements that an S corporation should be within, like you can't have more than X number of shareholders. All your shareholders need to be within the United States. And there are a lot of legal requirements that an S corporation needs to follow. So that's why it's not like the friendliest structure to adopt at an early stage. The second thing is with a limited liability, you have flow through taxation to your members, because an LLC, it's a creature of law, and it's a creature, you can put whatever you want in your LLC's operating agreement, and that's how you're going to run your company. But I always advise founders that an LLC isn't your best friend. That's not the structure you want to opt for, because it's invariably more complicated in that you have to put everything in your operating agreement. And then later on, when your company grows and you think you need VC financing or like other investors to come, institutional investors to come in, then investors are most comfortable with the corporation structure. It's been tried and tested and done multiples of times. It's been largely a successful way of doing things. So people like to stick to it. So my suggestion is, if you don't have something super, some pressing need, which, at this moment I can't even think about, then, it's always best to stick with the corporation structure. Then the other question people, especially in California, ask is, where should I incorporate? Should I incorporate in Delaware? Should I incorporate in California? Now, historically, investors also like Delaware companies. And that's because you have the best franchise tax rules in Delaware. It has good protection for board members against derivative lawsuit, shareholder action. You have consistency in the application of law. The Delaware court system, the chancery system, is set up in a way which is friendlier to corporations and corporate entities, because you don't always need to go through jury trials and everything. They have an entire chancery set up in Delaware, which promotes and helps corporations and other corporate entities to function more efficiently. There's less protection in Delaware for minority shareholders than in California. Like California will have like a requirement for cumulative voting. That's not required in Delaware. So all staggered boards are allowed in Delaware. They're not, sometimes allowed in California in private companies. So you have all these considerations. So best practice, I would say, stick with Delaware. Your third important thing, your second, I don't even know, I'm not even counting anymore. One of the critical pieces, and I can't stress this enough, in your setup, in your incorporation process, is agreeing on a capital structure. Now, the capital structure of your company is simply you have three distinct groups which are going to participate in and own your company. The first group is the founders. So the founders, they come up with the idea. So in the instance, the very instance when we incorporate you, the founders will get common stock, which might be subject to vesting or not. It might have acceleration provisions, it might not, but the founders will get a bulk of your common stock at the very moment that your company is incorporated. Then after founders, you have employees, because with founders, you're going to get your first batch of critical employees who will be working to get your product, sort of working to get you off the ground. And what do you do? A startup doesn't have money, so you compensate employees more in equity. And for employees, your equity comes out of your stock option plan. So a percentage of the company is going to be owned by founders, then a percentage of the company is going to be owned by employees. And then the third critical piece that comes in to help you grow your company is investors. And investors come in the form of VC funds, institutional investors, sometimes like, in more rare instances, but, PE funds and all too. But these are people who come and they'll come in with their millions of dollars, depending on how well your company is doing, if they find synergies, if they like your company, if they like your idea, they want to help to develop it. So your company is going to be owned by these three different groups, and you need to make sure that the issuances to each of these three groups is done properly. And your capital structure is, you just have to get it right. There's no, you need proper issuances. You need to follow and comply with the securities law and all. Now, whenever you're issuing stock in the United States, you have to ensure that you're in compliance with securities laws, because in the United States, you cannot issue a security, and a security is defined very broadly. It could be a note, it could be a safe, it could be common stock, it can be preferred stock, anything that sort of gives you an ownership interest in a corporate entity is going to be construed as a security. So you can only issue a security if you have an exemption from the securities laws, or if you are completely compliant and you have a lot of like disclosures and everything under the securities law. So you need to, at a small stage, you need to find a valid exemption so that you can be issuing the stock to your founders and to your employees and to any investor who comes in. Now, when you're formed, a typical structure will be that under your charter, you have 10 million shares, which the company is authorized to divide between all these various people. And in the first instance, when you're incorporated, you're not going to have investors. You're typically going to have 10 million shares authorized, 8 million, roughly 7 or 8 million will be divided between the founders. 1 million you're going to have under the stock option plan that, this 1 million can then be divided and, issued to employees who join. And 1 million is typically going to be unallocated, and it's just going to stay. If you need to increase your stock option pool or something like that, we'll take it from that 1 million. Remember, every time investors come in, your ownership is going to be diluted. So when you had your 10 million authorized shares, founders owned on a fully diluted basis 8 million out of 9 million shares on a fully diluted basis. So the founders own pretty much like 90% of the company. But now when an investor comes in, your authorized shares go up. You have 8 million still issued to your founders. 2 million, let's say your investors buy 2 million shares. And then 1.5 million you've had to, because you're growing the company, you have more employees, so you increase your option pool to 1.5 million. So now all of a sudden the founders percentage, which was first 8 out of 9 million, so now it's 8 out of 11.5 million dollars on a fully diluted level. So you can see that just with your first wave of investors coming in, the founders and everyone has been diluted, and this continues on. This is going to happen. You can't fight it, you can't change it until and unless you are the one who's bringing in the money. So that's just the model that you follow. Now, how do employees get an equity claim in the corporation? Now, typically startups will reward employees with equity. So what they'll do is, under the stock option plan that they've adopted, they're going to grant you options or RSUs or some measure of equity so that you have a vested interest in the company. Equity interests will be granted per the stock option plan, and the plan needs to be compliant with Rule 701 under the securities law. Now, again, Rule 701 gives an exemption for certain sales of securities for employees, consultants, and advisors. Now, if you're a public company, you're not going to have like a 701 plan, you have a different plan then. But the 701 plan is for private companies. You get to issue your stock and your options under this plan, and you need to really make sure that you're within the bounds of your 701 plan. You can't go beyond what the 701 plan has said that you can issue in a year without then giving certain disclosures and everything to the people that you're issuing these options to. You need to make sure that before you're issuing the options, that the board has approved these options that you're issuing to various people. And you also need to ensure that the exercise price of the option, it can't be below your fair market value. Remember that, you can't go back in time and backdate options. That's just illegal, that's wrong. You can't do that. So once you're incorporated, you're a very early stage company, you need to just make sure that, all these corporate housekeeping items are properly kept and you're doing right in all of these things, because otherwise, you might get a investor who wants to invest in your company, but they look at all your corporate work, they do their diligence, and they're like, oh my God, I found these thousands of problems with your stock issuances. They weren't correct to you, the founders, they weren't correct to this, that, and everything. And then you'll have to go back in time try and clean up a lot of this corporate stuff. So it's always, a stitch in time saves nine. It really, that's the way it goes for startups. Then another important part of your startup is, where is the value in your startup? Your value in a startup is inevitably, especially in technology startup, it's going to be in the intellectual property that the company has, what your product is, what your source code is that you've developed your product on. And it's incredibly important that founders and the company, they take all appropriate measures to make sure that they've perfected the company's rights to the intellectual property. All of these are properly assigned to the company. And, not everyone should, for example, if you have a trade secret, you don't want everyone in your organization to know your trade secrets. You have to, limit that to a really small group, because otherwise it's hardly that, you can't show in a court that you're protecting your trade secrets as a trade secret. Each and every employee that is founder or a CEO brings onto the company needs to sign a proprietary information and invention assignment. This is like a document whereby which your employee, and even founders have to sign this. They say that, okay, I'm working on this software or on this, developing this critical piece of technology or even non-critical piece of technology. And I acknowledge and I willingly assign everything that I'm working on and developing to the company. So I'm not the owner of it. The company is the owner of it. And this is something which is very, very important right at the inception stage of a company, because you'll have two founders who might, end up with a quarrel on, hey, I'm the one who came up with this technology, or I'm the one who came up with this technology and I own it, or the other person doesn't own it. Because you'll see that proper paperwork wasn't done, and these guys never assigned their technology, their inventions to the company in the first place. So lo and behold, now we have a successful company, a successful product, but we might be that, some key employee or some founder is suing the company, or they want to go different ways. And that's just, the valley is ripe with such examples where founders have fell out, or key employee, some critical employee has had a falling out, and then, there's a debate on who owns the technology and all that stuff. So again, it's always best practice when you get your employee in, when you get your founders in, sign on to a good PIIA, or the Proprietary Information and Invention Assignment Agreement, and make sure that all the technology, all your IP is assigned to the company. Then if you have a patentable technology, when do you file for the patent? And is the patent going to be in the person's name? It shouldn't be in the person's name. The patent should be filed on behalf of your company. The company should own the patent. And as your company grows, and if you have multiple patents, how do you file for them? When do you file for them? Because when you file for them, sooner or later, this all becomes in the public domain, because your patent is written and then held, archived. So what do you do? When should you file for it? When do you do the paperwork for it? All of these are important things which you'll need guidance on. And then protecting your trade secrets. Who gets to know the very, very most important, differentiating things about your product? Does everyone does all your rank and file employee know about this? Then it's really not a trade secret. Or do these critical 3 or 4 people know your trade secrets? And how do you protect that? Because, you're keeping that bubble of people who know these things very small. you're going to ensure that not everyone has access to these to this information either. So all of these things are things that you actively have to be thinking about, likely in the background, but you need to sort of think about these as you go along. Now that you are incorporated, you've got your paperwork done, you've got your securities issuances done, you've got your, your board has appointed your officers, your CEO, CTO, CFO, whatever you want. You have a functioning board. What do you do now? You have to go on. It's not that, you're done with everything at this point just because you have proper paperwork and proper documentation. You have to continue as a company which is, which actually believes and has espoused good corporate practices, and you continue with them. For example, you should have a regular board meeting, like once every quarter the board should meet, or like if you're like very tiny, like at least once in 6 months, once in a year. It makes sense for the board to meet, consider all these things, and then have board minutes, or if you're approving things, proper resolutions have to be passed by the board, and you need to keep them in your minute book. Or then if there's certain things that stockholders need to approve, for example, I want to change the name of my company. I don't like XYZ, Inc. Now I want to be called ABC Incorporated. So is that something that you can do yourself? No, you can't. You need your stockholders to approve, because you need to file an amendment to your certificate, or you need to amend and restate your certificate depending on the full extent of changes that you need. So you need your stockholders to approve that. If you just file a certificate without proper stockholder approval, then, hey, that's invalidly done. So you have to go back and fix that. You have to maintain good books and records. Your stock register has to be maintained properly. Way back when, people used to actually issue proper certificates for stock. These days, everything is on either Carta or some online stock register. But that stock register has to be maintained every time a stock issuance is made, and you need to put all that relevant information over there. You need to make sure that as you keep on growing, you get more employees and more people in. Everyone needs to be signing proper offer letters. Everyone needs to be signing proper proprietary invention and your PIIs. Just keep on getting them signed. You can't stop on those things. This is like essential. No matter what your size is, these things need to be done. If there's certain employees who leave, make sure you get separation agreements signed from them. And if there's like stock that they early exercised, and options that they early exercised, but now you need to repurchase them, make sure all of that is done. Then at a certain point, you're going to think like, oh my God, I need to raise funds for my company because I'm growing. I need more money to pay my employees, to buy, I don't know, like, licenses and all that, need to go into my product. All of those things, they require money. So who do you go to? You go to friends and family. You go to angel investors who are like, going to give you that 10,000, that 5,000, all of those things. So all of those, you need to ensure that when you're bringing in people, they're accredited investors. You're not just bringing on anyone, because you later down the road, you're going to come into certain problems. So all of these things, what I think a key takeaway should be, this is an ongoing process. You just can't sit back and relax. It's difficult being a founder. It's never an easy thing. It's even more difficult being a first-time founder, because everything is new. But these things need to be looked at, and continuously you need to be working on these things. So that was the end of what I had to, the nuggets of information and the pearls of wisdom that I could impart to you. If you have any questions or comments, I'm happy to take those on.
So thank you so much, Madhya. This was very helpful, very insightful, great presentation. I think one of the questions that came into our email inbox was, as a founder, when you're starting up your company, really at those early stages, and you might not have, capital available at that time. Many people are bootstrapping. So should they consider forming an LLC early on to save expenses like legal fee, incorporation fee? And if they do, can that LLC be converted into a C Corp or an S Corp later on, or will that need to be filed separately?
Okay, so great question. Not the first time we've been asked this. This is a question that comes up on a regular basis. Now, number one is actually setting up an LLC is much more difficult and cost prohibitive than a C corporation. A C corporation, you can, file very quickly. And because it's been done so many times and so many times again, you have standard format documents for these things. An LLC is a different thing. Remember, I said that an LLC is a creature of contract. And what that means is everything to do with an LLC needs to be put into your operating agreement. So if you want certain things, certain very key and customized provisions, all of those need to be drafted and put into your LLC agreement. Now, if it's a simple single member LLC agreement, okay, a form document might cut it. But if you have multiple founders and they all want certain provisions, then that's more cost prohibitive because someone has to sit and someone has to draft all those provisions and make sure everything's done properly, everything's tied up neatly, and then you file for it. So one, I think this notion that, hey, an LLC is the easy way to go. No. The better thing might be to just have your C corporation and have it taxed as an S corporation because you're just small, you're not many shareholders, and then you can maybe convert back into a C corporation taxed as a C corporation. But a corporate entity is always the more cost-friendly thing to incorporate. Now, let's say you have an LLC, what do? Can you convert your LLC to a corporation? Yes, you can always do so. But again, that's going to be done in most cases if you're more than a single member or two members. You're going to have you're going to have a reverse triangular small merger that is going to help you convert into a corporation. Or if you have under Delaware, you have certain other statutory ways for conversion, you can do it. But again, what you think you saved in your LLC is all going to come out on the back end when you're converting to a C corporation anyways.
Okay.
So I think the cost savings aren't as great or as huge as you think they are. So I think, again, like I told you, 9 out of 10 times, you're always going to go with a Delaware C corporation. So.
All right, thank you for that. So we have a lot of questions coming in the Q&A window. For all of those who are listening, there are two ways you can ask questions. Either you can type them in our Q&A window, or you can just raise your hand and we'll unmute your line so you can ask Madhya questions live over the webinar. So Madhya, the first question comes in from Shahid Abbasi. Shahid says, my company is incorporated in Pakistan and we wish to incorporate in the US as a Delaware corporation to be headquartered in Colorado, against which we will raise equity, right? The entity in Pakistan will become a wholly owned subsidiary to the
Mm-hmm.
US one. How should we proceed, and how much should we budget for such an exercise?
So again, you're going to start with, you're going to incorporate a typical C corporation. You're going to set that up in Delaware, and then you're going to have a merger with your, the C corporation is going to drop either another wholly owned Pakistani subsidiary, or you're going to have a simple merger with the Pakistani subsidiary so that the Pakistani subsidiary actually becomes a wholly owned subsidiary, and all your IP and everything, all of those assets go into your Delaware corporation. And your Delaware corporation will then have a stock option plan and everything, and your Pakistani entity is going to be issuing options or equity interest to its Pakistani employees and all via that the parent option plan. I'm not going to go into budgets, honestly, because I don't know what, the Pakistani entity looks like. What are the key constraints and everything on it. But you're right, you're on the right track. The good thing about a Delaware corporation is, like, although you're incorporated in Delaware, you have a PO box over there, you can have your headquarters anyway, and you can continue on. So they're thinking about it in the right way.
Right. So the next question comes from Alex. He's wondering, what do investors look for in a company? It's a pretty broad question.
Okay, so I think, like, when you're talking about venture rounds, that's a whole workshop in and of itself. But to the extent, what are investors looking for? Now, there are a couple of things. Number one, your product, your idea has to be something that they think is scalable, has a market, and it's something that is going to capture the interest of your ultimate consumer, right? If it's a B2B issue, then other business entities must have an appetite for what you're producing. Or you can at least convince them that this is the better way to go about and help make your business function a little easier. If it's a consumer driven product, then your consumers need to be at a point where they're willing to accept that technology, or they want to, or this is conceivably going to make something so much easier for them that they're going to buy into that. For example, Uber, that's ride sharing, any ride sharing app. That's something that, there was consumption for it. Because although at first I'm sure there must be, people must be hesitant that, oh, we have these taxis and everything, now we're just going to be in a stranger's car, and how does that work? But, there was appetite for it, both in terms of people who wanted to participate as drivers and as, people who were sharing the rides, and then people who wanted to take advantage of the service. So that's something I think that, investors are always looking for. And then no matter how good your product is, when they go and diligence, like look at your company's corporate work and everything, you don't want to present them with the worst nightmare scenario where, your corporate work hasn't been done, your board approvals haven't been done, your stockholder approvals were lacking. Oh my God, you're missing a basic action of the incorporator. So you want to keep sure that everything is done well. Because although most corporate paperwork, you can take remedial measures and clean it up, but you're just going to end up spending more in cleanup and fixing things and identifying what's wrong in the first place than just doing it right from the get-go. So that's my spiel about investors.
All right. So basically, a business case is one thing, but then you should have your corporate structure in place, which is very attractive to the investors. And making sure your books and records and your documentation is up to date is very important as well. Right. And I think an attractive capital structure, as you have explained from your slides, is something that will carry something which, there is some equity for the founders, some equity left for the venture capitalists, and then the
Yep.
valuation by the end of the day, how that is, if that's an attractive valuation.
Right. And the valuation is always going to depend on your intellectual property and on your product, right? That's where all the value of your startup is, especially for tech companies and all your product. And that's why I keep on repeating, it's critically important. Make sure you've perfected the company's rights in your intellectual property. You don't want someone coming at you with a lawsuit that, hey, I am actually the owner of this critical piece of technology, which the company says is mine, is there, the company's. So you want to make sure that all of those things are good. And then there's certain VC funds or certain investors who just cater to one industry and they don't cater. So like, there's certain funds which are just looking at med device companies or medical related health companies, and they don't want to invest in technology companies. There's certain which just look at technology companies. And even within the larger construct of technology companies, they look at, let's say, just B2B product companies or just consumer-driven companies. So, within the larger construct of a technology startup, there's a lot of specialization now. And a lot of people, like especially the funds and all, they've started to cater to certain specializations rather than just be like, oh, we're open shop for anyone and everyone.
So I think there are some questions in regards to international investors as well. Yusuf Mamsa, he asked a question: if the founding team has two founders who are US citizens and two founders who are international citizens, is Delaware Corp still the best way to go? And I'll tag along this with another question, which says, is it necessary to be a citizen of the US to register a corporation in Delaware? Can international investors also register corporations? So I thought they both go hand in hand. And
right.
You can probably answer both.
So we do have founders who are not US citizens. Sometimes they're residents and you form the entity, right? So you can do that. Is it possible for someone, you do, for foreigners can incorporate companies because the company is going to be the US citizen. The company's nationality is going to be US. So you can do that, but I think the context that I'd be looking for is if you're going to have additional founders who are here, you're going to have a headquarter which is over here, which, are you going to be working out of the US? Is the company going to have a proper US presence or not? So I think like there's a little bit more information which I would need on that, but it is possible. Yes, you can have that. You also have founders which are like, two founders are US, one founder is, let's say, in India or Pakistan or wherever. And it's just that when the company issues stock to the founders, then two of your founders will be in compliance with US laws because we know the founders are resident in the US, so we have to follow US law. There's certain founder representations which are given in the stock issuance documents as well. So the founders, they document that we're going to comply with US laws and all that stuff. But that representation can't be made for a foreign founder. So the foreign founder will just represent that they're going to ensure compliance with their local laws. For instance, if it's an Indian founder residing in India, then they're going to say, yeah, we're going to be compliant with Indian securities laws. and will make sure that, if there's a filing that needs to be made by them, then they're going to do that over there. So
is Delaware Corporation for such multinational founders?
Yeah, and especially in that scenario, I would say a Delaware corporation is better, the better way to go. So
there's a question from Mariam. She's asking, does your firm offer a special startup package? And if it does, what does it include?
Yes, the law firm, like most other law firms over here, does offer packages, and the package is for a and it's not at all cost prohibitive, but I think it's $5,000 or less than $5,000. Actually, I don't know the exact sum, so I'm sorry about that. But for a small fee, what the firm does is that they'll generate all your legal documentation for your startup to get you off the ground. We'll do the paperwork for your board consent, stockholder consent, action of incorporations. We'll write your bylaws. We'll do your filing in Delaware. We're not responsible for the Delaware fee, which is like a nominal $500 or something that you need to pay, but we'll get the process done. We'll get your founder stock issuances, we'll form your stock option plan, give you all the forms that you need for those things. And then for fee deferrals, then, the firm does offer fee deferrals and you continue on with the firm. With the understanding that, we're deferring your fees, but when you have a first round of financing of a certain level, then you'll pay our fees at that point. But your deferral is up to a certain amount. I think $25,000 or something in legal fees that you accrue.
Okay. We have a question from Asad, and Asad, you might want to rephrase your question because I'm just trying to understand. It says, do you need to have a lawyer and a CPA once you are a new corporation, or just a CPA? And I'm not sure because both are very different functions. CPA might be running your books and a lawyer might be looking after your legal framework. If you get two in one, I would love to see a lawyer who's a CPA. I haven't seen one yet. Maybe there is one.
I haven't seen a
but
lawyer
kudos
who's a
if
CPA. I know lawyers who have previously worked at maybe a PricewaterhouseCoopers or like KPMG or something, but I don't know who are doing both things at the same time.
Okay. So. Emma, I'm going to unmute your line. If you please go ahead and ask your question.
Hello, can you hear me?
Yes.
Yep. Hi.
You can hear you.
Yes. Thank you. Thank you for the sharing. So I have two questions. The first question is how staff deal with the legal issues when they just set up the company? Do they need to have the legal counsel inside the company, or just like mentioned, maybe better to cooperate with the law firm? The first one. The second one is what's the common legal issues will happen between the staff and the capital venture if they have? That's my questions. Thank you.
Okay. Well, thank you, Emma, for your questions. On the first one, if I understand the question correctly, you wanted to know. Wait, so her second question was on the
between staff, yes, and venture. Usually, if a venture investor, my company, for example, so what kind of risk or the some issues I need to pay attention to?
Okay, so the first one is like, do you need in-house counsel or not?
Yes.
In my experience, no. Companies, when they're small, I've hardly ever seen a company who's done at least like a series C or D or even E sometimes, like,
yes.
well into their growth. Mid-sized startups and all too, I don't think I've hardly ever seen startups with inside counsel of their own. Legal guys are the last people that they hire, I think. And that's when, the company is so large that, you're thinking about your exit event, be it a merger or be it a IPO. So you're already thinking you've grown so big. And that's when, they start hiring the legal team. Till then, they always cooperate with their outside legal counsel, and they keep on asking the outside legal counsel, this is the issue, this is what we need to do. And, your outside legal counsel sort of acts as your in-house counsel. They're giving you all this advice. Now, on the second thing, what are potential issues between your venture capital investor and the company? So when a venture capital fund or any investor comes in, usually they'll come in a bridge round. They'll want safes and a safe or a note. And they'll want to determine at what valuation will they convert. It's a convertible security that you're going to issue them on a bridge round. And what valuation are they going to convert into equity of the company? Because at a certain point, they don't want to be an equity holder as much as it makes sense to have a convertible security like a note, which will accrue interest as well. So your valuation that you want to put into your document, and how you calculate the fully diluted number at which they'll convert, which is going to go into the price calculation. Those might be issues, and they might want to see that, hey, where are you in terms of development of your product? Is your IP properly assigned to you? Your books and records, fine. Depending on how they want to diligence your company, that's what they're going to do. But when you're talking about a preferred round, I think a preferred round is a big corporate event, which has a lot of considerations. And, I think I can't do it justice in just like a 1 minute or 2 minute answer. Your venture financing is mostly when your investors come in and purchase preferred stock. And preferred stock, unlike common stock, has certain preferential treatments and arrangements, which, your venture capital, the fund or the institutional investor, whoever's coming in, they're actually going to negotiate all those points with you. And that's like a whole long term sheet of issues: registration rights, liquidation rights, conversion rights, rights of first refusal on founder stock. And also that's a huge universe of issues that they're going to negotiate with you. They're going to sign a term sheet with you, and then only will you be able to form those documents and then go on with the process. So that's a whole different thing. But that's my 20,000 foot, distance, like overall answer to your question.
Thank you, Emma, for your question. In the interest of time, we're going to take 2 more questions. One is from Samira. She's asking, are you also working with VC firms? She's in Europe and wants to set up a VC in the US, and she holds a green card, and her husband is an American. So I guess she wants to know, is it easier to set up VC firms in the US if you are a green card holder?
I would assume yes. We do fund formation, some fund formation work as well. But before you set up a VC fund, there's a lot of considerations that go into the fund, who's going to be managing it, who's going to participate in it, who's going to be is it going to be GPs and LPs and, like a general partner and then limited partners coming in? There's a lot of consideration that goes into it. But yes, you can set up a VC fund in the Valley, and VC funds, they tend to do well. So, I mean, right now, I thought since we're still in a pandemic situation, I thought that, it's going to be tough for companies and all, but it doesn't show that the market has slowed down. You have a lot of market interest. You have a lot of VCs who are investing actively in companies. You have a lot of companies who are expanding very well, exponentially. They're doing great. So thankfully, in the startup scene and the investors side, there hasn't been a massive slowdown which would bring the Valley to a halt, which is excellent news for everyone.
All right, so one question, it's a follow-up question from Shahid. He's asking that US citizen, do they need to own more than 50% equity to be registered in the US? Can you confirm that? If you, I guess this pairs with the prior question. If you have a US investor and a foreign investor, then the US investor need to have more than 50%? Doesn't matter.
No. I mean, if you're a US citizen and you're forming a US company, I have not seen any, I don't know of any prohibition on how much you need to own or not own. Again, ownership is calculated at a certain point. Remember, the cardinal rule is when your investors are going to come in and all, you're always going to get diluted. So your ownership stake is something that is a moving percentage. It's not going to remain static forever until you have the money and you're the one who's putting in the money. So, you keep your ownership stake. The most that happens is when your preferred stock investors, like your VC funds and your institutional investors come in, they negotiate pro rata rights, which means that whenever the company is going to issue new stock, they have a right to buy as much stock as they need to retain their percentage ownership in the company. So that's a right that's given to your investors, to your VC funds and everything. Founders don't have that pro rata right. Certainly you can buy into your company, but that's not a negotiated right in founder agreements and all. So your equity ownership percentage is always going to change. It's a moving target.
Right, and I think, Madhya, one of my good friends who founded a company gave me a good advice at the very beginning, telling me that when you're thinking about ownership and when you're committing to investors and you're committing to employees, always talk in terms of numbers of share that are you going to give them versus percentage, because once you offer somebody 2% or 3% in a company, you're locked in as far as the total pool of shares is concerned. Versus if you say to somebody, I'll give you 10,000 shares or 50,000 shares or 100,000 shares, you can always issue number of shares at a later point in time. That will, not offset your equity in the company. But once you offer somebody percentages, then you have to stick to that percentage and make sure that later down the road, even if you are offering more shares, you can be locking in those employees at a higher cost.
Right. And again, that's a great point. Now, I think, unfortunately, your founder friend, when he negotiated this right with whomever, he or she actually made that undertaking with them. He made that promise with them that, we're going to retain you at 3% or 2% of the company. So what that means is you've sort of given them a weird pro rata right where you're like, okay, no, the company is going to continue with your option issuances and also that we retain you at 3%, which is which is so off market and so weird. I don't even know why you would do it, but you're absolutely right. When you bring in employees, let's say today I own a company and there's someone who is critical. Let's say Farhan is critical to my product development and I need Farhan in there. So I'll tell Farhan, okay, I'll bring you and I'll issue under my stock plan equity so that you're at 2% ownership. So your 2% ownership, you need to make sure that that is as of the date I'm bringing you in. And that's going to vest over 4 years. Typically it's 4 years, like 1 year you work with me, you get 25% of the shares of that, of that 2%. And then the next 3 years, every month, certain number of shares, they vest to you. But that's something that you need to make clear, that your equity, your percentage interest is going to be calculated as of today. And I'm not taking under any obligation to maintain you at 2%, because that's just ridiculous. Farhan's absolutely right. You have to keep on getting all this options issued to them just to maintain a certain percentage. So when you bring in employees, mostly you say like, we are going to issue you, and that's in the offer letter, that we're going to issue you 500,000 options to purchase common stock, and you're going to be at an exercise price that the board will determine at its meeting when they approve your grant. So all of that has to be built in. But yeah, these are things that, first time founders, they sort of like, people can take advantage of them and say like, lock me in a 3% forever. You don't want to do that. You don't want to be that founder, because that's highly not market. You don't want to buy into that thing ever.
All right, so we're going to take the last question of the day. That question comes from Rahil. So Rahil, if you want to unmute your line. Rahil,
yes,
can you?
Thank you. Can you hear me?
Yes.
Yep.
Thank you, sir. Such an amazing webinar arranged by Open Silicon Valley. Appreciate that. Thank you, Madiha. This was really awesome. My question is that a startup offering 5% equity to the advisor, and the advisor can monetize that only in the case of exit or IPO. Is there any other way of monetization? Some of the time, startups think that, okay, giving like 2% equity or 5% equity to the advisor, that means that 2% or 5% is gone. Like my understanding, and please help me understand this, that percentage is just a piece of paper. If that startup gets to a level that they can get into an exit or acquisition by another company, then definitely it would be such an amazing opportunity. Or there's an IPO. Otherwise, it's just a piece of paper. That's my layman understanding, and I want to have your expert advice, please.
So thank you for that question. It's not paper. That's my short answer to that, but I'll explain the rationale behind it. Stock in a company, if it's a public company or a private company, and you've seen so many public companies, they IPO at like these amazing prices, and then something happens where their stock price plummets. So, then, what you bought at, let's say, $40 a share might become $1 per share, just because the company has been run poorly or they've been litigation with the company. So this happens in public companies as well. We've seen like so many giant tech companies like Yahoo and everything been run to the ground. Like, today nobody even knows about these companies, and you're like, wait, what happened over there? So that's just life. That's just the corporate cycle. That's just capital, the capitalist structures that we live in. So you need to run your company well. You need to be profitable. You need to have a good market share, and you need to have like your product, which there's consumption for that product. Only then will your your profit per share, your EPS, your earnings per share, all these numbers will look good only when you've got a good product, you've got a market for your product, your sales team is working well, and your company is generally run very well. Now, for a private company, I understand that, what you have, even if you have preferred stock or common stock, it's always going to be restricted stock. You can't buy and sell that on an exchange like you do with public companies. But in recent years, there has been a secondary market which has been growing for even private company stock. So private companies which are doing very well, there is an appetite for people to buy that. So sometimes advisors are given stock and, of course they need money and you're like, okay, what do I do with this stock? So you could get a, depending on how good or how bad the company is whose stock you own, you could enter into a secondary sale to another person who wants to buy that stock. But depending on what form of stock you have, if you have common stock, you always need the company to approve your sale, and you can get liquidity for your stock. Again, it depends how well or not well the company is doing. And that's just a rule across private and public companies. But to your point, for private companies, there are secondary sales. They do happen. We do paperwork for them every second day. Even within, sometimes VCs buy preferred stock and someone else, some other VC wants to buy it from them, or they want to, like, they're saying, sometimes VCs are like, okay, you know what, I'm not going to continue with all these investments that I have in consumer because I'm just pivoting my fund to just concentrate on B2B entities. So, they're going to make a decision and they might be selling all their preferred stock that they've bought for all these amazing consumer companies. So there'll be people who'll buy those preferred stock at very good valuations and all too. So there is liquidity. There's no hard and fast rule that you won't have liquidity. It's only that, when you're making those sales, there are certain securities laws compliance issues and, your company needs to. So if you're done properly, and if there's a purchaser out there for your stock, that can happen.
Thank you so much, Madhya, once again. I know we are way over time, but this has been such an engaging and informative session. And with that, we will conclude our day today. We're truly grateful for your time once again. Thank you for coming us for such an engaging and informative session. I'm going to share my screen once again for all those who are joining. Today's webinar was brought to you by Open Silicon Valley. If you have any questions you need to connect with us, you can email it at info@opensv.org, or you can email me, farhan@opensv.org as well. You can follow us on Twitter, LinkedIn, or Facebook. And we'll keep you informed of all such sessions that will be coming in future as well. A recording of this session will also be available on our YouTube channel. We'll email everyone and let them know once that recording is available, along with the link, so you can go back and listen to it as well. We hope, Madhya, that you also had a great time today. And we hope that you will be coming with some future equally good sessions on some more in-depth topics. And we'll look forward to hearing from you.
And thank you for having me. And I hope this was informative and helpful to all of you. Good luck to everyone in their future endeavors. Have a great weekend. And if you need to connect, Farhan has my contact details, so I'm sure you can go through Open Silicon Valley and we can be in touch.
Thank you, Madhya. Have an awesome weekend.
You too, everyone. Thank you. Bye-bye.